All right, let's dive into a Supreme Court case that honestly sounds like it's straight out of a movie. Picture this. One horrific crime, but two completely different groups confessing to it. This is the case of State of Maharashtra versus Ansari. And it really makes you wonder, what happens when a confession that could potentially free someone is locked away in a totally separate trial? So let's set the scene. The event at the heart of all this is the Mumbai train bombings. On July 11, 2006, 7 bombs ripped through packed local trains during rush hour. The human cost was just staggering. 187 people lost their lives, and hundreds more were injured. Now, the prosecution's case pointed the finger at one specific group, the Students' Islamic Movement of India, or SCC.
But here's the twist. This is the complication that turns a criminal case into a landmark judgment on evidence law. You see, in a totally separate investigation, members of a different organization, the Indian Mujahideen, also confessed, and not just to any crime. They confessed to carrying out the exact same 2006 train bombings. So how on earth is a court supposed to handle that? Two different confessions for the very same crime? That's the huge legal question we're looking at today.
Okay, to really get our heads around this, we're going to follow the Supreme Court's own logic. We'll start with the two confessions, then nail down the central legal question. After that, we'll walk through the court's analysis of 3 key areas: the general rule on confessions, the whole argument about relevant facts, and the exception for special laws. And of course, we'll wrap up with the final verdict and the key principles that you'll definitely want to have locked down for your exams. So, first up, a crime, 2 confessions. To understand the legal puzzle here, we've got to be crystal clear on the facts. The whole issue really comes down to the fact that there were 2 separate criminal cases going on at the same time, both centered on this one tragic event.
This table lays it all out pretty clearly. In one case, you've got the accused from SCC. In the other, you have members of the Indian Mujahideen who confessed in detail to carrying out the very same bombings. So naturally, these SCC accused looked at these other confessions and thought, hey, this is our ticket to acquittal. Their argument was pretty simple. If they confess, then we must be innocent. The real challenge, though, was getting that other confession in front of their judge.
And that leads us right to the main event, the central legal question. The SCC accused desperately needed to get the Indian Mujahideen's confession admitted as evidence in their own trial. But what's the legal path to make that happen? Is there one?
So what was their game plan? Well, it was a procedural one. They tried to summon the police officers who had actually recorded those other confessions. We're talking high-ranking officials here, like deputy commissioners of police. The idea was to put these officers on the stand and have them testify about the confessions they heard in that other case.
And this brings us to the very precise legal question that the Supreme Court had to answer. Can you actually summon a police officer from Trial B to come into Trial A and testify about a confession made by someone who isn't even an accused person in Trial A? This question really tests the fundamental rules of what can and cannot be used as evidence in a courtroom.
To figure this out, the court had to go back to basics, starting with the most obvious place, the confession rule itself, as laid out in the good old Indian Evidence Act.
Now think about it. Normally, what someone says outside of court is just hearsay, and you can't use it as evidence. But a confession? That's a major exception. The law kind of assumes you wouldn't falsely admit to a serious crime. But, and this is a big but, this exception has a critical limit, which you'll find in sections 24 to 26 of the Evidence Act. A confession can only be used against the person who made it. There's just one tiny exception to this in section 30. You can use it against a co-accused, but only if you're being tried together in a joint trial.
And the law is incredibly direct about this. Illustration B to Section 30 gives a perfect example. If the person confessing isn't on trial with the accused, their confession is simply out. It's inadmissible. In our case, the Indian Mujahideen members were not co-accused with the SCC members. They were in totally separate trials. So based on the confession rule alone, their statements hit a legal brick wall. No entry.
So, if the confession rule was a dead end, the defense had a plan B. They shifted their attack to what we can call the relevant facts argument. Their logic went something like this. Okay, fine. Forget calling it a confession. Isn't the fact that someone else confessed still super relevant to our case under other parts of the Evidence Act, like maybe Section 6 or Section 11?
First, they tried Section 6, using the doctrine of res gesta, which is just a fancy Latin term for things done. This rule lets in evidence of things so closely linked to the main event that they're basically part of the same transaction. You know, like if someone shouts, "He's got a knife," during a fight, That shout is part of the event itself. The key words here are immediacy and spontaneity. And when you look at this timeline, you can see right away why the res geste argument just didn't fly. The bombings happened in July 2006. The confessions weren't recorded until October 2008. That's more than 2 years later. The Supreme Court looked at that and said, nope, there's absolutely no spontaneity or immediacy here. A 2-year gap completely breaks any chain of events that could be called the same transaction.
Now, the defense's stronger argument was under Section 11, which is all about facts that make the main issue either highly probable or improbable. And here, believe it or not, the court actually agreed with them, in principle. The fact that another group confessed is without a doubt relevant. It makes it pretty improbable that the guys in this trial are guilty. But this right here is the absolute core of the judgment, and a distinction you really need to grasp for your exams. A fact can be relevant, but the evidence you use to prove it still has to be legally admissible.
So the problem wasn't relevance, it was the method of proof. Let's walk through the court's thinking. Step 1. Yes, the fact of the confession is relevant under Section 11. But Step 2. Section 60 of the Evidence Act demands that oral evidence must be direct. Step 3. Having a police officer testify about what someone else told them is the textbook definition of indirect or hearsay evidence. Which leads to Step 4. The only direct evidence about the content and truth of that confession can come from the people who actually made it, the confessors themselves.
With the general rules of evidence exhausted, the defense played its final card, the special law exception. They argued, what about the special anti-terror laws like Macaca, which was the law used in this case? Maybe that provides some kind of loophole to get the confession in.
But the court's answer was a firm no. They looked closely at Section 18 of MCOK and found that, while it does make confessions to police officers admissible, it has the exact same condition we saw before. The confession can be used against the person who made it and a co-accused, but, and here's the kicker, only if they are being tried together in the same case. Since this wasn't a joint trial, the special law didn't provide an escape hatch.
So, after methodically shutting down every single legal door the defense tried to open, the Supreme Court delivered its final verdict. And in doing so, it laid down some really crucial principles that help clarify the boundaries of evidence law for all of us. And this quote from Justice Kahar really sums up the whole thing perfectly. He says, the real goal here is to determine the truthfulness of the confession, and only the people who actually made those statements can vouchsafe for them. A police officer can testify that, yes, I heard him say these words, but they can't testify to whether those words were true. That is the fundamental difference between direct evidence and hearsay. So to boil it all down, here are the key principles from this case that you'll want to remember. First, a confession is only good against its maker or a co-accused in a joint trial. That's it. Second, res geste under Section 6 needs immediacy. A long time gap just won't cut it. Third, and this is the big one, relevance under Section 11 doesn't mean admissibility. You still have to clear the Section 60 hurdle of direct evidence and avoid hearsay. And finally, special laws like MCOK have very strict rules and don't create broad loopholes.
And this leaves us with one last, really interesting question to think about. The Supreme Court did say the defense had one option, call the actual confessors from the Indian Mujahideen as witnesses. But wait a minute, what about their right against self-incrimination? Forcing them to testify would make them admit to a crime. Well, the answer might just lie in Section 132 of the Evidence Act, which tries to strike a very tricky balance between the right to a fair defense and a witness's right to stay silent. It's a fascinating legal puzzle and a perfect topic to dig into next.